at her and she looks at me. In her eyes I see the sea. I don't see what she sees in a man like me. She says she loves me. Her eyes, yeah, her eyes. Her eyes are a blue million miles.
Alrighty. We have launched. Yes, we have. Welcome, everybody. This is officially Planet Green Trees Radio episode 150. We're calling it the Redden Case. Today is May 30th, 2013. The call number is 1-347-326-9626. Dial 1 to get on the air if you want to be heard. First, we want to give a big shout-out and really prayers and best wishes and strength for fast recovery go to our great friend, Warrior. So I'd like to call the professor. In fact, unbeknownst to what was happening, I called him a couple of days ago to ask him some technical trial issues that only I would respect his answers for, a few others. But anyways, John Targowski was involved in some kind of incident out west, and it's way back from the normal conference, and it's currently fine. He's just got to deal with some medical procedures, but we wanted to bring this to everyone's attention. It's obviously a setback for the community, and our prayers and thoughts go out to our dear friend John Targowski. But he's fine. He's still communicating. Everything's fine. It's just he's got to go through this hassle to get his way back home, I think. Tonight's show, as we said, is called the Redden Case. After 1,500 days of untold financial expense, this case in Oakland County settles for misdemeanors in Michigan's longest-running medical marijuana case. In the studio with us, David Rudoi, Rudoi Law, and also special guest tonight in the studio, Robert Lee Redden himself.
Bob
And
Redden.
we're going to be discussing the history of this case, its significance, and how it was ultimately resolved. Also, we're talking about really a very distressing, disturbing event this past week, what we're calling the federal POWs from Michigan. Jerry Duval, convicted in federal court for activity permitted under state law. Attorney Thomas Lavigne from Cannabis Counsel Law Firm in Detroit will discuss the conflict here of state and federal law. Also, statements from prisoner of war Ryan Basore and Lance Forsberg as they serve the first day of their sentences in federal prison also for activity permitted under state law, but charged under federal law. This is so distressing. What a terrible, terrible events. Core reports from our friend Steve Green of the Human Solution. We're going to also be spotlighting the Ohio Rights Group with Kevin Spittler, who is the Toledo area coordinator. I'm going to rant in a little while. We're going to have some current events news from Thompson. Rick Thompson's here. Thank you, Rick, for being here. The, of course, editor-in-chief of the Compassion Chronicles and much, much more.
Thank you very much.
Also joining us in the studio is Jamie Lowell of Third Coast Compassion Center.
Hello.
As I said, and not to David Rudoi, Rudoi Law, a co-counsel in the longest-running Michigan medical marijuana. Welcome, David.
Hello, hello. Always happy to be here.
Bob Redden in the studio, away from a microphone, but definitely in arm's reach. Thanks for being here, Bob. And, of course, Chad from the Birmingham Compassion Club.
Good evening.
None of this could take place without the following who I've just mentioned. So I want to thank everyone for their help and support, keeping the show going. I want to give a shout-out to our sponsors, Michigan Medical Marijuana Association, MichiganMedicalMarijuana.org. I want to thank all the moderators who participate and volunteer their time, creating a safe environment for the patients to evolve the conversation about medical marijuana. Also, Komorn Law, 1-800-656-3557. Back at our dear friend Kevin Spittler of the MedJoint Community Compassion Center in Ostemo, Michigan. Kevin, of course, is also going to be spotlighted tonight as the Toledo area coordinator in the Ohio Rights Group. And also,
the president from the Ohio Rights Group may be joining him as well.
Fantastic, fantastic. Me and Chad had an interesting experience in Ohio dealing with some activists, very fascinating, maybe add to the conversation. Also, our recent sponsor, the Marijuana Ranch, is hosting a 420 Funny. Your host...
Oh, the 420 Funny is good.
Yes. Your host, Black Coffee, presents a comedy cafe jump-off at the Marijuana Ranch Cafe, 2627 John R. in Detroit, Friday, June 7th. Bill Hill, Martini Harris, Mocha, and R&B sound by Mike Loud. Showtime At doors, 9 p.m. Doors open at 7. $15 advance tickets. Buffet and grill food, $3. And call 1-313-422-5281 to reserve a spot. Participate in the 420 Funny, hosted by the Marijuana Rancher. Okay. So I got an exciting show tonight. A lot of history involved with the main topic tonight, Bob Redden, in the case. And I want to rant about that a little bit, then we're going to take a break and come back and get right into it. But, there's a lot of different ways you can tell the story of Bob Redden's case. It's almost too difficult to really put into any kind of rant. I could do a 2-hour rant and maybe get a third through it. I won't torture everyone with it, but, there are some specific facts that need to be known about the Bob Redden and Torey Clark case. Fact number one is that Bob Redden and Torey Clark were the people that Michigan voters were thinking about when they passed this law. Both of them have very, very serious debilitating conditions. What can be taken away is this fact that the prosecutor's offices throughout the state, especially in Oakland County, have taken a very strict policy on strict scrutiny to the physician certification. Fact is that Bob Redden's case has always been about one thing and one thing only, and it's the legal technical analysis of the physician certification. If you may remember, this case started many years ago in the district court in Madison Heights. When the testimony ended and the arguments concluded, the court issued a ruling which was a dismissal pursuant to the Michigan Medical Marijuana Act. Quotes from Judge Turner were, well, in regards to the doctor, this doctor testified and it seemed like they spent more time with him than I do with my doctor. So the first view of this was like nothing wrong with the doctor. The judge sitting there listening to the testimony live, evaluating the testimony. The doctor came in, making evaluation, said, doesn't seem like any problem here to me. Needless to say, the prosecutor's office took the position that this can't happen. I think part of it, if I may say so politically, was that the certified physician, Dr. Eisenbud, was seemingly criticized statewide, not specifically him per se, but what he purportedly represented, which was a physician coming in from out of state, setting up shop and doing exclusively medical marijuana certifications. For some reason, that is offensive to the opponents, giving access like that. When in fact Dr. Eisenbud was doing a tremendous service, and I do commend him for his work in Michigan. And I mean that because I had an opportunity to interact with him on this case. And I will tell you, I've read numerous certifications and the process that goes on in that certification. I will tell you that the one engaged in this case with Bob and Torey was one of the best that I've seen comparatively to the others across the state. He knows and understands medical cannabis. He did a thorough examination, evaluated records, and signed a form and gave them instructions about follow-up. Solid certification. Yet despite all that, the case was challenged vigorously in the trial court, in the circuit court of Oakland County, because that was the first level of appeal. It went to the Court of Appeals and was the first of any of the Michigan medical marijuana cases to be issued with any precedent at all. And while the opinion was a reversal of the ruling, they reinstated the charges, of course, sent it back to the district court. But what came out of the case, which was so significant, was this outrageous concurring opinion by Justice O'Connell, which set off some of the worst precedent that could have ever existed. And but still, at the same time, the criticism of the case and the legal rulings that came out of it was based upon the fact that there remained questions for the jury as to whether or not the certification process was in fact done properly. And as I said, the Bob Redden and Torey Clark case has always been about the physician certification. And what's fascinating about this case is it went forward and came back from the Court of Appeals and was assigned to a new trial judge. Well, it was first circuit court judge, Judge Denise Langford Morris. And which we all supported. There's so many dynamics as to how the courts rule and act, and again, too much time to really go into all of it. But needless to say that me and David Rudoi took over the case after some other lawyers were representing Bob and Torey. I think that there wasn't much litigation that was fought. There's a couple motions that were filed, and there were some offers that were made. I remember conversations about pleading as charged and taking a 7-year felony and, maybe no jail, things like that as the impetus. And you just knew at that time, and this was as recent as December 2012. Am I right? This is like when this thing went down, when Langford Morris had issued her opinion, which essentially, amongst other things, had denied any defenses that had been provided. And limited what could be said. Anyways, needless to say, me and David Rudoi got involved in the case and filed, I think, and Aaron Ingber, who worked very diligently on the case, and I can't say enough for what a good lawyer Aaron is. Unfortunately, he's practicing civil law now. But we filed, I think, like 15 motions, and they were all reflecting and addressing all of the legal principles that had been not specifically addressed. And I think it was, let's say 13 and a half out of the 15 motions that we filed were all denied, something like that. And a lot of people asked about what the issues were, but there was one specific one that I really thought we would have gotten better traction on, David, and correct me if I'm wrong. There was the attack of the affidavit. The basis by which the search warrant was signed was based upon a trash poll, and in the trash poll was a substance like marijuana, which they then tested in the Lavigne preliminary test, and they said tested positive for marijuana. That was what was in the affidavit, but in fact they never produced, nor could they ever saw this purported item. And the argument that we made that I thought that our judge had taken notes on, later never to be mentioned in her opinion, was that when you do these the Lavigne test, this preliminary test, it's got to be some kind of material. It's not just some something like substance. It's got to be something that you can identify and drop into a container and add other chemicals so you get a coloring from the mixture and whatnot. Anyways, so as we moved forward and had these motions denied, there was only two issues that remained. The first issue was the search warrant as to whether or not one existed at the time that they went into the house. We had a fascinating go at it, 2 or 3 days of testimony related to officers, and we tell you the number of things that were uncovered almost incidental, which is that during the course of officers calling in to speak with the magistrate who's going to be reviewing the affidavit that they are going to look over and then determine if probable cause exists, oftentimes ancillary discussions take place between the officers and the magistrate, which is not how it's supposed to be if it's not on the record. And it's not something where it's a lesson, like your affidavit says this, well, it should say this. It's a test. Does the affidavit, in the magistrate's mind, rise to the level of probable cause? But it's fascinating to hear. The magistrate, of course, seemingly was much more in denial of that activity taken on. But the officers, oh, yeah, we talk on the phone. We discuss some aspects of the warrant, blah, 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 blah.
We guarantee that there was something in there that would be illegal.
Absolutely. But David, from a legal perspective, you remember this testimony coming out, and it was some other things that we had obviously lined up. Anyway, so we've gone through 3 or 4 days of testimony. We had reserved the right to write our briefs in support of it, and we were beginning to order the transcripts, and we came back to finish up, or start, I guess, our Section 8 hearing. Now, Section 8 hearing had been going on for a long time, but we never really got going. The reason why was because we had prepared to go, and on at least 2 occasions subpoenaed and set up this certifying physician, Dr. Eisenbud, to be ready to testify to that he's a professional and as a physician, and that statement made in the course of a bona fide relationship to satisfy the elements of prong 1. And what was fascinating about the factual background was that we had provided to the prosecutor's office, for the first time, the medical records and the documents associated with the certification. And within those documents, you saw very clearly that there had been a physical exam conducted, an interview, notes taken, medical documents, medical records reviewed by the physician, and a discussion and suggestions for methods of ingestion and a return date in 6 months. It was in both Torey and Bob's certification.
Really qualifying conditions.
Yes. Without question, and again, I guess if there's a significant fact that can be taken from this, as I'm going to conclude, it's that all this trouble went on independent of the fact that 10 out of 10 doctors would have agreed that Bob and Torey's medical condition met the criterion of a debilitating condition. Whether they would have signed it or not is another story, but they would all agree that their medical conditions were those conditions that would have warranted therapeutic relief with use of, or could bring therapeutic or palliative relief with the use of medical cannabis. Anyways, and remember, for the purposes of where this goes and the Fifth Amendment and a doctor being threatened about testifying, and that if he did, he was going to be committing a crime, understand that Dr. Eisenbud had testified at the preliminary exam in Madison Heights, that he provided much information about the certification of what took place, so much so that, as I said, Judge Turner said, well, sounds like what takes place at my doctor's office. And, of course, the prosecutor's office had an opportunity to do their cross-examination. But we'd now provided the prosecutor's office with records from the certification they had not had before. They had it for a long period of time. And one would suggest if an identifiable crime had taken place that could have been pinpointed, then charges would have or should have been brought. But instead, what we found really odd, troubling, is that upon the day that we showed up to, and with Dr. Eisenbud on a video camera, it's Eric Van Dusen has videotaped it. Dr. Eisenbud is instructed that if he testifies at today's hearing, he's in jeopardy of having a crime charged against him, which is insane. All of a sudden, a physician who seemingly is protected under the Michigan Medical Marijuana Act for doing nothing other than signing a certification is committing a crime. And the allegation was that he may not have, the allegation from the prosecutor's office was that, one, he did not participate in a bona fide relationship, and two, that by signing a certification of some kind, he was creating a false medical document and putting it into a medical chart, or so was alleged and discussed. We weren't even really certain or clear of to whom the prosecutor's office was speaking of whether it was Torey or Bob, but needless to say, Dr. Eisenbud he should have took the Fifth Amendment, because who is going to risk losing their medical license to testify in a case that they could easily say no? And I mean, I'm not, listen, if I'm his lawyer, I'm going to recommend that, and that's just, everyone understands that. It's the right thing for him to do, and any lawyer that's represented is going to look out for his best interest, independent of whatever cause. But I'll tell you something, that Dr. Eisenbud was, in fact, a believer in this, and I know in his heart that he wanted to testify, spent a tremendous amount of time on the phone with him, and he firmly believed in everything that he did in this case. And it's but for the threat of a felony and losing his license, I can tell you that one of the things he would have testified to was after 35 years as a licensed ophthalmologist and being on the board of ethical committees, he had never had a complaint against him in 35 years. And here he finds himself, and with the last 5 or 6 being exclusively doing medical certifications in various states. And here he finds himself being dragged in and threatened for a felony. So,
Beth Hannes intimidated him the first day in court when she made him spell his last name.
I know. And but without mentioning specific names, and we'll refer to it as the office's policy, I think, because it's really a political issue. But nonetheless, we believed at that time that there was something very suspicious about this. Suspicious in the sense that we want to call a doctor. We've got a defense we want to present, but all of a sudden that witness is being threatened. And while they do have a right to take the Fifth Amendment to protect their interest, the judge has to be certain that it's a good faith interest, and it's not just to avoid having to testify, and that there's a justifiable reason. Because we, as representing the defendants, and the defendants specifically has a Sixth Amendment right to compulsory process, and we can ask of the court to help us bring our witnesses to court and make them take the stand. Okay? So these two are some very interesting competing interests, but what we did instead was we went out and actually got the treating physicians for both Bob and Torey. Well, what does that mean? That means that, as I said, the treating physicians, in this case, had long-term relationships, were not in a position where they were going to sign a recommendation that could be sent to the state, but would not ever disagree with the idea that they were people that qualified and that cannabis may help their medical condition. And we had spoken to and had some conversations with the various physicians, and I will tell you that the last place that they wanted to be was in court, and they would have told you that their marijuana is trouble as medicine, not because of its medical effect on a condition, but because they've got to come to court, and that legitimacy cannot be had if doctors are threatened in participating in the program, which is why they are so resistant. I'm talking about an institution such as Beaumont Hospital. I'm talking about a oncologist at Beaumont who was treating Torey. Needless to say, after discussions in a very, very odd and weird encounter, one of the doctors that we planned to call to testify had some conversations with the prosecutor's office and with their lawyer present, and somehow what came out of that conversation was the possibility that that doctor from Beaumont may also find himself with criminal charges. And when we called him to testify at the beginning of our Section 8 hearing, there was understanding that he too was going to take the Fifth Amendment. Now, in response to that, we were armed and ready to go with a number of different constitutional arguments, which I think would have brought a lot of attention to this, much more attention to this case. There would have been a lot of criticism on a specific office policy, and I think that there's also a lot of years ahead of us in this fight. Issues such that weren't guaranteed to win, but clearly issues such as possible misconduct, threats to a witness, due process, specifically the right to present a defense, interfere with witnesses, all these kind of things come to mind, and there's legal principles that would be argued. But nonetheless, in this moment of how things were going, for the first time in the 5 years, a discussion began about disposing of the case in a way that never had been offered. And I will say that, as lawyers, we all know, David will attest to this, I've heard every other lawyer that I've spoken to agree to this, that to win the war on marijuana, prohibition, every case should go to trial. But there's so many of them that every case goes to trial, doesn't plea, the system will be blown up because won't be able to handle it. And furthermore, most juries don't want to convict. Well, no one disagrees with that. However, when a lawyer represents someone, it is about what's in the best interest of the client, not what's in the best interest of everyone in the community. Because at the end of the day, you're not anyone that, until you're walking in the shoes of a defendant for 5 years, you don't know, and you've never been there. As I say week after week, you don't want to be no one. To my worst enemy, I wouldn't want you to be part of the criminal justice system. You have no idea the psychological torture, the physical torture that goes on. As a lawyer, we go to court, we leave court, we come back to court. It's part of my regular routine. But take yourself out of your normal daily life and the pressure of being involved in it is something you cannot explain, and it will wear on you. It'll have an effect on your health, your mental health, and your physical health, and it is overbearing. And in this particular case, I will tell you that I can't say that I know of anyone that has been more heroic to the cause than Bob Redden and Torey Clark. I mean, the crap that has been thrown at them, what they've had to endure, the various negative interactions with other lawyers, the pressure of being where they were the first one out of the gate and standing where they are now. I just cannot say enough of the courage and desire and heart that they had as representing the community and standing for what they believed in. And no criticism should be given whatsoever for them wanting to get out of the case. At the point where this case happened, the purpose and cause and nature of Bob Redden's case originally had been resolved. The Section 8 defense had been clearly defined. The tools, albeit, that all should have been protections for Section 4 now exist under Section 8. That's because of Bob Redden and Torey Clark, that their case made it to the Court of Appeals and right out of the gate defined and acknowledged these issues of questions of fact. And amongst other things, while this case is about doctors, it's created an interesting issue in Oakland County that I think, more than anything, opens up the doors for the types of groundwork that were laid relative to these due process issues and these possible misconduct. But also, I think, from the community standpoint, if anything, it cries out that the way in which medical cannabis certifications have been known and readily accepted are not going to suffice for the time being in court. There are new amendments requiring a certification every 2 years. One would argue in Oakland County this is a trap. If you think going and getting a certification on day one and coming back after 1 year is enough, as you would rely upon your physician to tell you, if it's now 2 years, I'm telling you that is going to be a failure if you're defending yourself under Section 8. And this is a lesson that Bob Redden's case should also tell us. Because whatever we all think and want to believe, however we want to believe the interpretations, it's been defined and fought out in the Bob Redden case. And it tells us, for those that want to win, if you're going to be and you want to go up against these monsters that are going to criticize and play doctor from the courtroom and make the statement that they know better than the physician, understand what the Bob Redden case stands for. It's that there's got to be an interaction with the physician. There's got to be an ongoing relationship and an intention of that. There's got to be more than just a certification. That there should be other types of interaction, either by phone, I'll say Skype, writing, that the doctor can say that they know and understand what is happening with the patient's serious debilitating condition with the use of cannabis. So this case, I could go on. I am already ready to wrap it up here, but there's so much here. We're going to talk about it because David Rudoi is going to tip me off on a lot of other things I'm going to want to talk about and then interrupt him when he wants to talk. But on the surface, I want to, again, just thank Bob Redden as he sits here, and we're going to hear more from him for his courage and Torey's courage and fighting as long as he did. Went to the round of the final round, the championship fight, the 15th round, and I will tell you that in the circumstances that he finds himself in, with whatever prior issues are in his life, in the last 10 years, there's, I'd say, nobody who's gotten a misdemeanor plea in the circumstances that Bob Redden was in, medical marijuana or not. And that in and of itself is a victory. The fact that he's able to have a limited, very innocuous probation with no issues regarding his treatment of his serious debilitating condition being affected is a victory. The fact that he can stand back and say that he got what he wanted from the case and he's been able to get out of the case, put an end to it, and continue to advocate, continue to fight and represent what this case stands for and help the community stay out of trouble and be that person. This is a victory, and the community should laud it as such. And that's my rant for right now. We're going to obviously get back into it a little bit more. In the meantime, we're going to take a break, and you're listening to Planet Green Trees. We'll be right back.